the Chief Learning Officer at the National Constitution Center, and I'm going to be your host today. But I am so happy, lucky, and thankful that I am not alone in this great work. We are here with Professor Bruce Murphy, who's going to dive into the Fourth Amendment with us and engage in a conversation on the history of the Fourth Amendment, how it applies, why the founding generation put it in there in the first place, what are some modern implications of the Fourth Amendment and how technology is testing the limits and testing the bounds of the Fourth Amendment. And then he also promised we'll look at the Fourth Amendment, not just in our daily lives, but also the crossover with public schools. So much to go into. And as I kind of dive into that, Professor Murphy, I want to give a proper introduction and all your background. But first, I want to welcome and thank you for being with us today.
It's a pleasure to be here, Kirby. Thanks very much for asking me.
It is always so exciting to have you here with us. And also, and the students know I have a lot of favorites, but you're definitely on my top 10 favorites. And I was telling the students before we started, the reason why is because you're a fantastic teacher. We work with you all the time in our summer teacher institutes, but you also just really take every single question that comes from our teachers, from our students, and from me. So I really appreciate your ability to dive in and look at that. Now, a little bit about Professor Murphy before we dive into this topic. I want you to know kind of where he comes from and amazing books that he's written as well, because that is going to be an era that you might want to jump into a little bit later after class, because we always like to say that we give you homework, and the homework in this class is for fun, and you do it on your own time, but there's great things to read, and we're always assigning those materials and those pieces. So I will begin with Professor Murphy is judicial biographer and a scholar of American constitutional law and politics. He is the Fred Morgan Kirby Professor of Civil Rights at Lafayette College, which is in Easton, Pennsylvania, and he has held this position since 1998. Prior to this appointment, he was a professor of political science and a professor of American history and politics at Pennsylvania State University. Professor Murphy is the author of 4 judicial biographies and co-author of a textbook and an editor of a reader. In addition, he is the author of many books, speeches, and articles. You can Google him and find fantastic videos with the Rendell Center as well. They're some of my favorites. I watch them often to prep myself for these classes. And throughout his academic career, Murphy has taught political science, history, constitutional law courses, including American constitutional law, liberty in the United States, the First Amendment, an introduction to the U.S. politics, the American presidency, and of course, many seminars on the judicial branch. So this is why you're great at taking questions, because you're so well versed. But today we're going to focus on the Fourth Amendment and dive in deeply. So I know we always like to start with the text at the Constitution Center. So I'm going to share screen and put the text up there. But can you walk us through the words of the Fourth Amendment? And then we'll dive into the story and the question of why did they put it in the Bill of Rights? What happened to the founding generation that they were this concerned about being, in that first beautiful line, being secure? People have the right to be secure. I love those first few words.
Sure. The text is coming up. Do I wait for that?
Sure. There you go.
There we go. So if you ask somebody about the Fourth Amendment, they're going to tell you that it's all about stopping unreasonable searches and seizures. And then they're going to tell you that the key word there is unreasonable. And that is exactly right as far as it goes. But like the Second Amendment, the Fourth Amendment has a sort of prefatory modifying clause, the right of the people to be secure in their persons, houses, papers, and effects. So that's the indication of what it is that the framers were trying to correct. This whole amendment is designed to limit government's power to search for evidence. And it's describing in that preface the kind of thing that they don't want. Whatever that was is by definition unreasonable. The rest of the Fourth Amendment, after the unreasonable searches and seizures, sort of describes the process that you go through to have a limited warrant. And the second key phrase there is probable cause, a reasonable belief based on available evidence. You have to go to an independent arbiter, a judge. You have to swear out with an oath a request on probable cause. I have a crime that I think has been committed or is going to be committed, and I believe the evidence is in a particular location. And then you are asking for permission to search in a particular place for a particular thing. So I can just go forward, Curry, and talk about what it is they're trying to avoid. This is an interesting amendment because it really has two aspects to it. There's a spatial aspect, and then there's a personal autonomy privacy aspect to it. The spatial aspect. What they did not want were writs of assistance. They did not want a general fishing expedition, total search power, which the colonial British troops had. They could go in looking for evidence of contraband, evidence of not paying your duty or your customs on approved goods sold by the British government trying to pay for the French and Indian War. And it gave the customs officials and other officials total power to go through all of your belongings, your entire house, read all of your letters, look at your journals, look for evidence that you paid your duty. It was a total search power. That to the framers was unacceptable. They were looking for a way to limit that power. So they wanted no writs of assistance. If you ask what is unreasonable, it is a writ of assistance or a total fishing expedition search. But if you go to old newspapers from the colonial times, which I did, an old database of early American newspapers, and I put in the word privacy, you get nothing. What you get is privacies, plural, of life. And privacies of life are something more than spatial. It's you can't go into this place and you can't tell me how to lead my life. And I think that protects personal autonomy, privacy as well. So the purpose of the Fourth Amendment, as I understand it, is to limit the search power of the government, no unreasonable searches and seizures, no writs of assistance, to protect your spatial rights, but also to protect your privacies of life.
And that is unbelievably amazing, like kind of the way you lay it out, and this idea of these general warrants, these fishing expeditions, that they could just go in anywhere at any time and look for anything they want. And it clearly defines like the lived experiences of the colonial period and why they were so worried about this overstepping of the government, that any petty officer could come into your house whenever they felt like it and look for anything that they wanted. And so it's really specific location, what it is, where it is, when it is, all those pieces. And as we kind of dive into this, you know, we have this original 1791, the Fourth Amendment is added to the Constitution. It is spelled out, but how do we balance that as the years go through? And is it always so clear cut that it is a privacy of a person's mind, a person's ideas, and a person's self? Or does house and place play a different role when we get into, I'm thinking of the Olmsted case in the 1920s, and say, that one always blows my mind, that they're like jackhammering up a sidewalk and you tell the story, get our suits there. And they thought that was not an invasion of privacy.
Yeah. Yeah. I mean, that really does raise the key question of how do you define seizure? You think of seizing papers or you think of seizing evidence, but in the Boyd case in 1884, which comes before Olmsted, the government figured out, well, if you're telling us we cannot conduct a search in a place without a warrant, what if we force the potential defendant to do the search for us? What if we give him a subpoena? We want you to come to us, ducas tecum, with items. We want you to come to us with the evidence. We know that in your office, in your cabinet, your file cabinet, there should be receipts for the plate glass that you are selling, that you are supposed to have paid tax and duty on. But if you don't have those receipts, then in fact, that's contraband and you should be punished for that. So we can't go to a judge and say we have probable cause to search through all of your papers. We don't know which file these papers might be in, or if you even have it. How about if we say, you become our deputy, you search, you bring us the evidence that in fact you are innocent or guilty. And what Joseph Bradley said there was, If you look at this, it's a violation of both writs of assistance and personal autonomy, privacies of life. Because what you're doing is you're having this person go into his files, get materials, some of which he might have written himself. So it's a Fourth Amendment issue and a Fifth Amendment issue, and it violates his indefeasible right of personal security. It violates the sanctities of his home. It violates his privacies of life. Now, that same concept should have applied to Olmstead, except for the fact that what William Howard Taft did was look at the amendment as a property-based amendment. Did you actually go into this fellow's house to try to find out what he was doing on the phone, whether he was selling bootleg whiskey? No, you didn't, because you were able to get evidence from the wires that transmitted the phone conversations outside of the house. And Taft said, you're not seizing anything. All you're getting is electronic impulses, which you can then translate back into words. Well, if you look at it that way, it's a privacy right and there was no trespass, you didn't actually seize anything, then there appears to be no problem. What I love teaching students about, though, are the dissents. First of all, as you said, Oliver Wendell Holmes makes clear, basically the government's a criminal here. They're breaking into the house. And then Louis Brandeis is saying, well, you've got to update the Constitution. And what's happening is you have a right to be let alone. Again, the privacies of life. You should not worry about people hearing your conversation when they're outside your house. And so what Brandeis is saying is, if you are outside the house, but effectively you have transmitted yourself inside the house to hear that conversation by your ability to seize those electronic impulses and know what the conversation is, you have violated the Fourth Amendment. So he's telling us you should update the Constitution, you should have a right to be let alone. And he actually, in that dissent, talks about the day in which they might use psychics to try to intercept the thoughts of an individual. And in fact, when you look at the cell phone, it's the modern version of those cases. If you can get into the cell phone, essentially, it is a file cabinet of everything in your head, what your searches were, who your conversations are with, where your journals are and your notes to yourself. To me, looking at the cell phone and comparing it to Boyd in 1884 and Olmsted in 1928, it shows you how you have to update the Constitution to make the words of 1788 more relevant today.
So many awesome points there. At first, I love the Boyd case because you're pulling in the idea of the Fourth and the Fifth, and then incriminating yourself as well. Like, you have to go in and find your own evidence to prove you're innocent, or in a way proving that you're guilty. So really fascinating grouping those two together. So thank you for bringing that case up. I don't think we've talked about it all week, so it's a great one to add into this Friday class. The other idea, and I never thought of the way Taft saw it, that he heard sound waves as not being tangible property. And because I was wondering if there was a connection between the fact that back then, it's the 20s, it's the late 20s, there's a telephone operators, and there isn't really as clean of privacy on the telephone as it is today. And it was that a part of this, but it's so much more interesting to think about how this idea that sound waves are coming through the wires and you're just capturing something that's not real. And the more that we learn science, the more we understand that these properties are real. They're just different definitions. And we always do love diving. And that is one of the best dissents to read, because you're watching Brandeis try to figure out, he's like being like Star Trek, trying to figure out what the next world will be. And like talking about the cloud computing and FaceTime and like all those pieces. So the idea of taking the principle of 1776 and the principle of 1787 and applying it to future technology is going to be key to a lot of the questions the students have in there when we get to cases like Carpenter. And how does this change? Now, I didn't know if you wanted to do a detour on the way to Carpenter to Katz and talk about a reasonable expectation of privacy. And in that case, just the simple act of shutting a phone booth door and what that means for an expectation of privacy. And I'm going to be just honest that maybe half of our students don't know what a phone booth is, so you might have to explain that too.
I think Kiefer Sutherland shot it up in the last movie that he did about phone booths. Sure, I'd like to take a double detour, but I won't make it too long. Because when you look at Mapp v. Ohio, it is the kind of spatial privacy case. They broke into the house. They didn't have a warrant. They conducted a classic modern writ of assistance search. We all understand that. And the conclusion by Tom Clark was, you have an expectation of privacy. You can't do this. Katz is different, because Katz, they know they can't go into his house to prove that he's a gambler. They know that they can't go into a hotel. They know that he is using a classic old Superman style phone booth where you step in the booth and you shut the door. And the minute you shut that door, you are expecting privacy. And the problem is, if you intercept that conversation inside the phone booth, you might hear the other people on the phone on the other end. You might hear other people who have nothing to do with the crime as they use the phone booth. So they came up with a classic solution. They put an electronic bug on the top of the phone booth, and they would only turn it on when Mr. Katz went into the phone booth to do his business. Now, here's the issue. The issue is not the majority opinion, Justice Stewart, because all Justice Stewart is saying is the minute you shut that door, you have asserted your Fourth Amendment rights. And the minute you do that, you deserve a search warrant, because what this is a Fourth Amendment, and this is where he makes the big change, that is based on people and not places. Don't be thinking this is about an office. Don't be thinking this is about your home. It's wherever you go. And so he says, if you do this kind of thing outside of the booth, if you're here talking on the phone with a long cord outside the booth, you are displaying all this evidence to the public. It is in plain view. You have forfeited your Fourth Amendment rights. You're not covered. The minute you do it in that phone booth and shut the door, you are now asserting your Fourth Amendment rights. And so he says, when that happens, you have to get a warrant. We are trying to protect you from the uninvited ear. And that is what he is doing. Harlan, Justice John Harlan II, is the important opinion here, because Harlan asks the additional question, is that booth private or public? I don't know. Other people can use the booth. The booth door can be open. I need a way of describing how I'm going to do an expectation of privacy analysis. Now, here's where it gets a little fuzzy. The way I had always understand it, the way I still understand it, the way that I will go to my grave arguing it, is that all that Harlan does is he says there's a two-step test. You have to assert an actual subjective requirement for privacy. You have to do something that indicates I want privacy. And your assertion of that privacy has to be something that society would accept as being reasonable. So I always believed the test was societal expectation of privacy. What would the people think would be private? But the double detour now is the Jones case. And that's going to be in the 2012 era. And that's going to be Antonin Scalia. And he's got a bit of a problem. You have a fellow who's dealing drugs. He's using his wife's Jeep Cherokee. The police know it. They don't have the resources to follow him with drones. They don't want to follow him all day with cars tailing him. They come up with an idea. His Jeep Cherokee, his wife's Jeep Cherokee, is parked on a public street. What if we take a GPS device and put it on the bottom, the undercarriage of that Jeep Cherokee, and then just track it wherever it goes for 28 days? So they do it. In fact, I believe they have to replace it because the battery runs out. But it's always in the public space, and the device never goes inside the car. It's under the car. They get 28 days of data, 2,000 pages. They know everything about where he goes. Scalia looks at this, and curiously, Scalia, who is very pro-police for hard evidence searches, is very pro-defendant for electronic devices. He wants to protect Mr. Jones. What he could have done was say society would never think that that is an assertion of privacy, but he wants to protect Mr. Jones. And so what he's going to do is he's going to go back to Taft in Olmsted, and he's going to say that they have violated his personal property. They have trespassed because they've gone underneath the back bumper beyond what is called the curtilage of his property, and they put that device on his property. Now, I'm not clear on what happened here. I wanted to really talk to Jeff about this, and I'm sorry that we're missing that opportunity, because it appeared to me as though Scalia wanted to overturn Katz. But later in the opinion, he says, no, I'm going to make a choice. I can do both of these. I will look at the property, and then I will look at the reasonableness. And so he is saying that I can choose one or the other as to what to do. What I find interesting is that in a concurring opinion, Samuel Alito says, I don't need to do that. I'm just going to use reasonableness. And I'm going to ask, was the crime that this person committed, was that so bad that you should track him for 28 days? And he says, that is totally unreasonable. I'm not going to allow it. But if he had been a terrorist, I might have allowed you to do a longer search than just 7 days. So where we are coming into the electronic searches is a little unclear to me, because I think one way or the other, the court has to accept what Scalia has done and basically diminish Katz or place it side by side with Olmsted, or it has to say, no, we're going to go with Alito and we're going to continue to use reasonableness. Now, do you want me to go forward to electronic searches?
We are, but we have to ask a question around that because I'm seeing the chat go up too. And so at what point, Warren's comment was it can be a slippery slope. And the question I have on that is kind of where's so getting a warrant is one thing. Getting a warrant, having an agreement and amount of time that you can search and how you can search, where they put the device on the car, when the car's in the driveway, when the car's on the street, like all these things come into play, which is why I think I love the Fourth Amendment so much, because there's so many it depends moments in that. But at what point in time, and we know this happens throughout history, is it too subjective?
Mm-hmm.
And it is saying that it is too high, the subjectivity of this is too high, and what are the clear boundaries and rules around that? Do you have any insight on that before you jump to the technology and tracking people using technology?
I'm going to give you a classic political science answer. And the answer is going to be whenever you can get 5 votes. What are the 5 members of that court going to say? 5 or more votes. We're not just talking about warranted searches. There can be warrantless searches. We're just going to try and find out what's going on. And remember, we're not talking about probable cause anymore. We're talking about a world in which you're building a certain amount of information, what some people call the mosaic theory. I'm going to take individual data points of where this car went and when it went there. And we're trying to get enough evidence to then go to a judge and say, Your Honor, look, we know that this person is dealing drugs. Here's all this information. Now we would like a warrant to go into his house. Now we would like a warrant to go into his storage area. Now we would like a warrant to go into his car or his office or whatever. So it is very subjective, very subjective. And what I really want to encourage people to do, and truthfully, I missed the importance of this when I first taught the Jones case. And it was Chief Justice John Roberts who schooled me in his Carpenter opinion. I missed the importance of Sonia Sotomayor's opinion in Jones, because she saw that you are both missing the major point here. You think the major point is, are you safe from searches because you are in your car and so you can't have your personal property privacy violated? Because clearly we know they could not get this evidence by tracking the phone inside the car. It does not matter, Scalia said, that it's outside the car on the undercarriage. You went past the bumper, and so I'm saying you have violated his property. And Sotomayor is saying it does not matter what kind of crime he's committed and how long you're searching. So the reasonableness test doesn't work. What really matters is if I look at the evidence you've got, the 2,000 pages, the 28 days, I can tell you everything about this person's life, It's the tracking of this individual that is the problem. She sees that it's not a spatial privacy problem. What it is a privacies of life, personal autonomy problem. I know where you eat. I know what sporting goods store you go to. I know what kind of recreational activity I know what your party designation is. I know everything about you. And that's what bothers her and John Roberts in the Carpenter case, about being able to use this cyber, high-tech, long-distance informational searching about getting cell phone records and then using it to track wherever these people go.
And that, we were just having a conversation on Monday about the First Amendment, and that your freedom of association.
Yeah.
By being able to track somebody that much for that long, you can tell who they hang out with. And that starts to, overlap and interplay so many other rights as the freedom of conscience, what you believe, where you go, where you worship, all those pieces are overlaid into that. And I love that you point out her writings in this, because it comes up in a few other cases.
Mm-hmm.
I'll remember the name of the case. There's a case, it was basically based off of Terry v. Ohio. And it was, can you, stop and frisk?
Utah versus Strieff.
Thank you. That is the case. And I found her writing on that unbelievably powerful, of saying, no, you're going down the wrong road here. And it's a dangerous road because you're going to make jumps and assumptions. So thank you for bringing that up. We love so much about reading all the opinions and all the dissents and the concurrences. And I love that you're weaving that into the conversation. Okay, so let's hit Carpenter.
Sure.
And talk about the ability of a cell phone to triangulate your movements so you actually see all these pieces. So in the chat, they were talking about like CCE cams that you have in other countries that watch and see, and we have them here as well, and drone tracking, but your cell phones are doing that. My Waze app is totally tracking everywhere I'm going, where I'm shopping, all those pieces. And how does this interplay between private company information and government information crossover around warrants, no warrants, and tracking of people? I know that's a lot to unpack.
That's a great question. And so what we have to do first is separate out I can track that car on cameras in banks and on traffic lights and so forth, or I can track that car using cell phone data. When you're being tracked by cameras and you're just driving your car, you've already waived your Fourth Amendment rights. You are out in the public space, and all they're doing is they're saying where the car is going. They're not necessarily saying who the driver of the car is. What's different about this is, in order to get a cell phone data off of a cell tower, and we are talking about a specific kind of cell phone data. It is historical, in the past, cell phone data. It is not real-time data. I am sure that what they're able to do when you see those signs on the billboards, we're looking for a silver BMW because there's an amber alert or there's a silver alert. I'm sure they're also playing with real-time searches on phones or whatever they can do, going into the Wi-Fi of the car to find that car. That's very different from this historical data. They wanted 127 days of historical data on Timothy Carpenter. 4 months. It's close. It's like 11,898 data points. It's almost 12,000 data points. And all they were trying to do was say, when this Radio Shack was being held up for cell phones, ironically, was Timothy Carpenter in that building at that time? Because they knew from other material that he was part of this gang. That's all they're trying to do, is track him. But to get that information, they had to go to the phone company. It's what's called a third-party search. And so the initial problem is the way that the government does this search. The rules, the laws that allow for a third-party search, that is, I'm going from a private company, you have data on a suspect I would like to try to investigate. Would you give us that data? And we've seen this discussion with Apple and other organizations and other businesses, but it was designed to go to banks and get canceled checks. It was designed to go to a phone that had what was called a pen register, basically caller ID. Where did you call and who called you? But it's not designed for the electronic digital age where you have month after month of data just sitting on a tree, a tower, and you can just tap into that and know where this person is going. The problem with doing that is, first of all, the individual has not given the right to the company that they're dealing with, oh yes, allow the police to track me. It's a question as to whether or not that is a valid, voluntary, non-assertion of Fourth Amendment rights. They're going to have to update the third-party search. Let's go past that now. So I now have the data. Everything I just said about Sotomayor's opinion in Jones applies here. You not only know whether he is a robber of Radio Shacks looking for cell phones, you know everything about Timothy Carpenter. And so if we allow that kind of tracking of people using this data, it opens it up to the government saying, fine, here's a bunch of other things we'd like to know. And let's just put a whole number of people in there and see what we get. Almost like a fishing expedition search, but it's a writ of assistance on everyone. That's what John Roberts sees. I love John Roberts' opinions, both in Riley, which is the basic, can you search through the cell phone, which I find funny. I love the image of the Martians coming down and seeing a statue of a human being, and in their hand is going to be a cell phone. I just laughed out loud, and you don't laugh out loud reading Supreme Court opinions very often. But he understood that he picked up that concept of privacies of life, and he uses it in these electronic search cases, and he credits Sonia Sotomayor in her opinion in Jones for that insight. So I think he's been very clear, but there's so many variations. If you think of Alexa, how many times does Alexa just speak to you and answer a question that you weren't asking? You were asking somebody else in the room. You just aren't aware that they're constantly recording and they have all this information. All of this is going to come into play in future cases.
And I find it, again, why I love the Fourth Amendment, because it's so interesting. Like, I didn't realize the Roomba is actually mapping your house.
Wow.
And then selling the data to furniture companies. And then you get an ad where they're like, oh, this couch will fit perfectly in your living room because they know.
And here's a little picture of it.
And you're like, oh my God, this does fit perfectly in my living room. Well, because they know. So it is, but yeah, the Alexa listening to, like, it really does. It's fascinating. So I love technology. I love the fascinating things that technology do, but it is also when a private company, you give the permission to a private company to have this information, that does not mean you give it to the government. And our scholar on Wednesday, Tom Donnelly, pointed out, I love the line he said, because the government can put you in jail with it.
Right.
And that's the line. That's the big, big difference here. They have power to take away your liberty. Right. And this is why they are under a much, much stronger saying, no, you can't have that information. And I thought it was a really clear way to think about this. Now, we could keep going on for a million years. And now I feel like Jeff, because he never wants to stop asking questions, I will ask you just one more hint of questions. And I'm not sure if you know this case. Vicky, I think it was Vicky that asked earlier about what about DNA? And I know there's a few DNA cases with the swab with athletes, but the DNA case that always blows me away is they're trying to find a murderer. He was a multi-violent killer and other things. And I thought it was brilliant of the police. They went through like something like Ancestry.com to try to track back who this person was. And in a way, I thought it was brilliant police investigation, but it still crosses that line about where your data is going and how they can track you, not just your movements, but who you are in your DNA as well. So any kind of points around those cases that you want to bring up before we dive into a few questions?
Sure. The case that you're talking about is Maryland versus King. Can you do a cheek swab, ostensibly to identify the prisoner, but in fact to send it to the CODIS case file, the cold case file of the FBI, and solve previous crimes? I mentioned this last time I was with you folks, and I will mention it again. That is an opinion that is worth reading, but the opinion that is really worth reading is Scalia's dissent. And the line that is worth remembering is that the colonial individuals would never have opened their mouth to royal inspection. He really doesn't like that whole process. And I've done a fair amount of reading on the Golden State Killer and the DNA searches.
Thank you.
And what's interesting about this is it's not just that the individual suspect has waived their rights. I don't think some of these people use 23andMe in some of these services. It's that all of their distant relatives have had their DNA analyzed, and they didn't realize that they were waiving all of their privacy rights. This is a third-party search. So when the police come and say, can we get all of this information? They get the information. And it's not just that you look in a computer and suddenly up pops the suspect. It is that you have world-class genealogists who have to create family trees. And sometimes they get it wrong and they go and search some fellow in a retirement home and it wasn't him. And then they have to go back. I think this happened to the Golden State Killer. They have to go back and look at another tree and try and find another individual. So there are real privacy questions and third-party search questions about using people's DNA. We haven't even discussed, and this kind of laps over into the Obamacare cases, what if you combine that information and the government asks for the information because they want to help insurance companies make evaluations of who should get insurance and who shouldn't? This problem of intermixing such personal data on an individual with an organization or a governmental structure or a business that can use that information for their own purposes, it is what the 21st and 22nd centuries will be about in constitutional law.
It is fascinating. And again, going back to Brandeis, it's seeing into the future and understanding, like he's like mystically thinking of cloud computing, and now we're mystically thinking of like DNA traces. And you're right, the killer wasn't in the system. They tracked it through a distant cousin. Mm-hmm. I found that case so fascinating because it sounded like a sci-fi book. You're reading it. It's a horrible case. So if you dive into it, pre-warning here, it is extremely violent case to dive into.
Can I also mention, I think her name is Michelle McNamara, Patton Oswald's a late wife. She was the one who actually broke the case because they didn't actually get that individual. They knew that there had to be somebody with these kinds of spy-like skills, and there happened to be an officer in a certain area. There's a lot of really good investigative police work. I think there is a documentary on that on one of the streaming channels, and her book, Alone in the Night, or I'll Be Gone in the Night, or something like that. It's worth taking a look at.
Awesome. Thank you. And I appreciate you talking about that. Tom always hates to talk about that case, and I always want to talk about it. Okay, a couple questions in here, and a lot of them actually do with one kind of general idea, and we knew this was coming, so we'll get to the privacy idea. But let's begin with Bev's question. Does the Fourth Amendment only apply to the federal government's unreasonable search and seizure? If so, are people throughout the United States protected in their homes from local and state government? It's kind of an incorporation.
That's a great question. And after the events of this week, stay tuned. We'll find out. You're talking about the question of incorporation or the application of the Bill of Rights to the states. Until 1961, so we're talking about 61 years ago, until 1961, the Fourth Amendment only applied to the federal government. That's what MAP v. Ohio does. Earl Warren told his clerks, find the worst search ever, get me a writ of assistance search, and they came up with Dalry MAP search. And he used that as a way of explaining why the Fourth Amendment and the exclusionary rule, if you violate the Fourth Amendment, you can't use the evidence in trial, the Fourth Amendment applies to the states. Now, when you look at what is going on in, say, the gun rights case and the McDonald case, that's what this is all about. What is the standard now for applying the amendments to the states? Is there an entirely new rule than there used to be in the 1930s? I won't dive us into the weeds here. Is it the Palco test, or is it some version of Alito's test relying on Rehnquist in the McDonald case? Right now, the Fourth Amendment applies to states and localities, and it applies to states and localities because the Map v. Ohio incorporation case is still good law.
Got it. Okay, so the last question will kind of bring us home because we're a little over, but that's okay because this has been so much fun. Colin and others have basically asked this idea, and we're seeing in the courts today, you know, coming down with the Roe case being leaked. And I want to ask you, being an expert on the judiciary, that actually happened, how unprecedented is that? But the question that Colin has is, when looking at this idea of privacy, do we see this idea of, so his question is, do you think the Fourth Amendment in combination with the First, the Ninth, and the 14th, really packing it all in there, Colin, create a right to privacy? What would consequences be of the right of privacy if overturned in Roe? So two questions there is, where do we see this idea of privacy? We hear it now when talking about the police and our privacy of our effects and papers and belongings, the right to be secure, and in other amendments as well. And then I want to talk a little bit about how unbelievable that this leak was, and have we seen that before in the courts, and what's the process?
I'll take it in the order that you just gave me. And that's an excellent question about a combination of rights. And it takes us back to Boyd, because that's what Bradley was saying. There is a penumbra between the Fourth and Fifth Amendment, and I need to use both of them to keep you from going into this man's office to try to make him search for evidence that you can't find otherwise. On the combination of the First, Fourth, Ninth, and 14th, can I expand it to the First, Fourth, Ninth, 14th due process and 14th equal protection, two different provisions of the 14th. And that is exactly what Douglas tried to do in Griswold versus Connecticut. He actually had the First, Third, Fourth, Fifth, Ninth, 14th due process. He had 6 different provisions. He then realized later on in 1973 in an abortion case that was released the same day as Roe, Doe v. Bolton, I don't need all of that. All I need is the Ninth Amendment and the 14th Amendment due process clause and the 14th Amendment equal protection clause. So it's a triangle, the Ninth, the due process, and the equal protection clause. And he said, I can do whatever I want to do. And yes, that combination of rights would protect privacy. Again, wait for it, political science on soapbox talking, if there are 5 votes to do so. And that's what we've seen now with the difference between Kennedy in the Obergefell gay marriage case and Alito in this draft. Kennedy in the Obergefell gay marriage case identifies where he thinks those rights are for same-sex married couples, and he says they're in a combination of the 14th Amendment due process clause plus the 14th Amendment equal protection clause. He sort of uses Douglas's approach, but he doesn't use the Ninth Amendment. He will not, though, apply the highest level of scrutiny to the same-sex married couples. He doesn't give them strict scrutiny rights. And now Alito. Alito's not doing any of that. Alito's going back to where Rehnquist was in the assisted living case in Washington versus Glucksberg. I think it's 1995. He's saying, I'm going to look at which rule will apply a right to the states. And I'm going to use Palco, implicit in the concept of ordered liberty, which was the rule, but I'm going to add to it Snyder versus Massachusetts, 4 years earlier, same author, Benjamin Cardozo. And the rule there is, I'm going to look at the traditions and consciences of the American people, what is called history and tradition. I'm going to do a survey of what the laws said prior to that. Now, what's interesting is that Alito has changed the rule from what Rehnquist actually said. He intended, I think, to use Snyder, Palco, and Duncan versus Louisiana in 1969. Update everything to 1969. What have the states done? I'm going to rely basically on Palco and Duncan. Alito seems to be saying, I'm only going to talk about Snyder. If you look carefully in that draft, he says the rule is the 2 cases, but he really never uses Palco. He's only using Snyder. So if he can get a majority of the court to agree with him that his use of Snyder does not allow for this to be a liberty, then that is what the law of the land will be. That said, let's go to the leak. Absolutely unprecedented to have an actual draft opinion in a working case released. We've had some leaks, not many, half a dozen, possibly a dozen. You mentioned Dred Scott at one point. I would talk about just 2 years ago, 2020, Joan Biskupic, legal journalist, she had a whole description of how the cases were decided that term. But it was not real time. It was after the fact, and it was a description of information that she had gotten. This one, we can actually read the draft opinion, and then we can read the final opinion. And people have to understand, this is a work in progress. They may have already changed the vote. And what it says to me is there are 5 votes then in February for that opinion. But I don't know where Chief Justice John Roberts is. So is Chief Justice John Roberts using this reaction that we see now and going to maybe Justice Kavanaugh, maybe Justice Barrett, maybe Justice Gorsuch, and saying, look, this will destroy us. This will make us a political court. This will put a target on our back. Can't we just do the 15 weeks in the Mississippi law and uphold that? Can't you just wait a little while? I mean, it's until they actually mount the bench and read the opinions, it's very much up in the air what this will be like. And we are going to be looking at that final draft, the final opinion, and we're going to be looking at the draft opinion for any changes, and we'll be able to figure out, okay, this is what probably went here.
So, and I think it's so unbelievably important to say, like, nothing like this has ever been leaked. It is not procedure. Definitely was not Roberts who leaked it. Don't imply that in any possible way. It wasn't like he wanted to test the waters, but there is a tradition of being able to have civil discourse and dialogue and work through issues and ideas and concepts. I mean, that's how the Constitutional Convention happened, and that this leak comes in, is unprecedented and unheard of. That this has never happened in this sense. Students, we are going to have a class on May 20th. That'll be the final class of our public season, and we are going to talk about the court cases. It may not be out by then, but we will definitely talk about this in more detail. But Bruce, I wanted to thank you so much. I love the way you walk through those methods and the other cases. I just love watching your brain work there as a constitutional lawyer. So really fascinating. But students, like, watch how he did it, looking and analyzing it and saying, it's not about what they should or shouldn't do. It's about what are they doing, why are they doing it, and what is the constitutionality of their choices, and what is the evidence that they're citing or the evidence that they are not citing. That is the truth when we look at opinions and dissents and concurrences, and that's the truth when we look at these cases too. So thank you for modeling that behavior for our students and how you analyze these opinions and how they're analyzing the cases. Really great methods there. Thank you so much for this fantastic class. And I wish we had 3 more hours.
My pleasure, Kirby. Thanks for asking me. It was great fun.
Great fun. Thanks. I will be bugging you again soon enough. And
Anytime.
Students, thank you so much. And yes, I wish we could talk about Prairie View, Ohio, but I will send you a brief on it, Mohammed, in the link. It is one of my favorite ones to talk about. Next time, we'll talk more about that. And maybe we can sneak it into Clark Neely's questions next week, too, because he did some work on that. Thank you so much, Professor Murphy. Have a great day.
Stay well, folks.